Welcome to Cause for Counsel.
Welcome to Cause for Counsel with Erin Skinner, founder of Erin Skinner Law. Erin provides fractional general counsel services to growing businesses, helping companies navigate contracts, compliance, employment issues, and operational risks with practical, business-minded legal guidance. I'm Lisa Mosbey, your host, and today we're talking about why businesses often benefit from legal guidance much earlier than they expected. Welcome, Erin. Thank you so much for joining me today.
Thank you for having me. I'm excited to be here.
Erin, before we get into fractional general counsel services, can you share a bit about your background and what led you to build this kind of practice?
So, thanks, Lisa. I actually always wanted to be a lawyer, but I didn't go to law school out of college. I actually started in the home building industry after working for a construction firm during college. And then I was working in the home building industry, and the industry had that crash in 2008. So I figured I needed to make a change, and I decided to get my paralegal certificate and started working in a law firm. And from there, I was encouraged to go to law school. So, with the support of my husband and the encouragement of family members, I did decide to do that. And I went at night while I worked. I continued working at a law firm and then had the opportunity to start at the federal government. So, I worked at the Centers for Medicare and Medicaid Services, CMS. And that's really what started my legal career and my, I guess, passion for healthcare. Um, and when I was there, I worked with the compliance program guidelines. I helped rewrite Chapter 9 or 21, which is the compliance program guidelines. I developed audit protocols. I worked on the Sunshine Act or the Open Payments Program. I worked on Stark Law. It was really great to have the experience with writing regulations, giving feedback to the industry when they had questions about what certain laws meant. I helped with auditing, I helped with enforcement. Um, and then one day I was talking to one of my colleagues and she said, "We are just improving healthcare one beneficiary at a time." And I looked at her and said, "You think that you do that?" And she was like, "Yeah." And I was like, "I am definitely not doing that." I just felt so disconnected from the agency mission and it kind of stuck with me. And I realized I wanted to make a change because I didn't feel vested with what I was doing anymore. And it's really important to me to like what I'm doing, to love what I'm doing. So I had the opportunity to transition into a consulting role, which I did. And from there, I worked as a healthcare consultant. I worked as interim chief compliance officer for a multi-state health plan, and then an interim Medicare compliance officer, and then ultimately transitioned into some in-house counsel roles for healthcare technology companies. And I concluded my in-house career as general counsel for two healthcare marketplace staffing companies. Um, and I realized that, working in that role, that companies always need lawyers and have sometimes the right counsel is not your in-house counsel, it's your out-house counsel that can be your part-time general counsel. And that's why I do what I do.
It's a winding road. I know you've mentioned that to me before, that it is a winding road to get educated and have all these diverse experiences so that you can bring them to your clients. And being a fractional general counsel is just the perfect role for someone who has all the experience that you have. And I know a lot of business owners are familiar with hiring a lawyer for a specific issue, but not necessarily having ongoing outside counsel that's available when they need it. What does a fractional general counsel do day to day?
The honest answer is it varies a lot week to week, which is part of why companies value it. But I'll give you a feel for what it actually looks like. In a given week, on a Monday, I might be helping a client think through whether to push back on an indemnification clause that a customer is asking for. And then Tuesday, I could be reviewing a lease agreement for a location expansion and flagging inconsistencies with the LOI that we just signed. And then Wednesday, I'm working with HR to navigate an allegation of discrimination from a departing employee. And then Thursday, I have a new healthcare client and we're drafting a business associate agreement. And then Friday, I'm on the phone with product and we're discussing if a new product line even makes sense. So, what ties it all together, though, is that I know enough about the business and I'm embedded with them and I'm embedded with the people and the strategy. So, when something comes up, I'm not starting from zero. I'm not billing you while I get familiar with your company and the operations so that I'm up to speed. I'm not the lawyer that you're calling when something's already on fire, though I get those calls also. I'm the lawyer who helps make sure that fewer things catch fire in the first place. And I'm a member of the team. I'm just part time.
I think that's the most critical part is you're part of the team and we all need someone who's got our back, who's looking out for us. What are some of the early business decisions where having legal guidance in the room can make a meaningful difference?
Yeah, a few come to mind, and they're the ones that are actually pretty cheap to get right at the start, and then they are more expensive to fix later. The first one that founders should be thinking about is how they want to classify the people that are doing the work. You want to think about whether they're W-2 employees or 1099 contractors, and if they're exempt or non-exempt. Normally, you're going to want to default to whatever feels easiest at the time. And then 2 years later, you're going to have a regulator who's asking you a question, or there's a class action suit because your employees are unhappy or your workers are unhappy about how they've been classified and the founder didn't see it coming. So you can get this right with a 30-minute conversation with counsel, and then fixing it later could cost you six figures. Um,
Wow.
the second thing that I think about is your contract. Your first MSA or services agreement that you sign is normally going to be your template because that's what you become familiar with and that sort of sets your standards. So if your indemnification or your limitation of liability or your IP terms are sloppy, then they're going to be baked into your book of business because that becomes your standard. When you go to raise capital or you sell the company or you go through any sort of diligence, then people are going to see that. The third point, and this is really true more in healthcare or regulated spaces where I've spent a lot of time, is just making sure that your business model really fits into your regulatory framework from day one. When I worked in healthcare staffing, one of the things I saw was that the companies weren't paying attention to the regulatory models and requirements for licensure. And so if you have a beautiful product and you don't realize that the way that you're operating comports with the regulatory structure and the licensure requirements, you can really find yourself in trouble. Or if you're handling data in a way that implicates HIPAA or changes the way that you're classified under a certain law, then you can find that it's costs a lot more to clean that up later instead of putting the controls in place initially. So early legal guidance isn't about saying no, and it's not about creating barriers. It's just making sure that you're creating a foundation that you can build from.
So, Erin, some business owners assume legal support only becomes necessary once there's a dispute or major problem. What important work is happening long before that point?
Yeah, that's a fair question. I see that a lot, but the honest answer is that by the time there's a dispute, most of the decisions that are going to determine how to resolve the dispute were already made. The dispute is just where the decisions are becoming visible. And so here's an example. One is your contracts. You're going to look at your indemnification clause, your limitation of liability, your IP assignment, if there are restrictive covenants or termination provisions. Those terms are going to tell you how you can resolve the issue at hand. So if you have a well-drafted contract, it's going to be the difference between a difficult conversation and a six-figure expense. Another example is your policies and procedures. If there's ever a question about how your company handles data or how you responded to a complaint or how you're training your workforce, you need to be able to point to something. And if you don't have those documents, then you're not able to explain how you're doing your business. Mistakes still happen, but documented policies applied consistently and training will change how you handle those conversations.
Makes sense. And I know you've worked both inside companies and now as outside counsel. How does that in house experience shape the way that you work with business owners and leadership teams?
I think that the biggest difference is it makes me appreciate what no means and the impact that it has on a business. When you're outside counsel without in-house experience, it's really easy to say no and see that as a safe answer. It's defensible and you won't get in trouble for telling a client not to do something. But when you've been in-house and you've sat in board meetings and you've sat with the product team or you've sat with the operations, you understand that there's a cost to saying no. You know that that means it slows down product and it slows down people's performance evaluations and it slows down reporting to investors. So the question isn't, can we do this? It's, what are the risks? How likely is something to happen? What's the cost if we avoid them? And there another way to get where we want to go? Um, so that means I'm thinking about things like, does the consent mechanism that you've put into your terms of service create friction when you're onboarding customers? Is that an additional cost to you? Is your indemnification posture actually protecting you, or is it blocking your deal? When I worked in house, I'd sit in product meetings, I'd sit in board meetings, I'd watch the sales team try to close, and you see how these conversations happen and you see what actually matters to getting the deal done and making money. So when a founder calls me with a question, I'm not answering in the abstract because I've been on the other side of that call. And I'm answering it knowing how the business is actually functioning and what matters to them. Our outside counsel without in-house experience can answer a legal question, but a fractional general counsel can answer the business questions also because I'm part of the team.
And that's what you need as business owners. That makes total sense. For a business owner listening who assumes they're too small for fractional general counsel, what would you want them to understand about how this type of relationship can support growth?
Yeah, I think that there's an assumption if you need to hire a fractional general counsel that you have a lot of legal work to do, and that if you don't, then you don't need counsel. And I think that is sort of a backwards perspective. Sometimes the companies that benefit the most from this aren't the ones that have a lot of legal work. They're just the ones that might need some legal judgment in a few key moments. Sometimes you just need someone to bounce a question off of. And so here's an example, like, if you're a small business and you call a law firm with a question, you're going to pay to talk to a partner, you're gonna get that partner up to speed, then they're gonna send you a bill. And small business owners are gonna think, "I'm not gonna make that call next time because that just cost me $1,200." So the questions don't feel serious enough to have counsel when they need a judgment call. Having this outside fractional counsel relationship allows you to have that part-time support of an in-house counsel relationship for those kinds of questions. So a new product idea that might have regulatory implications, you can ask that question and you don't get the $1,200 bill. You can pick up the phone for a 15-minute conversation. Um, it's access that's often more valuable than you'd expect.
I want to jump back here. Something that just kind of popped in my head. When companies are growing quickly, where do you tend to see legal issues start surfacing operationally?
Yeah, that's a great question, and I think one of the biggest spots that I see operational issues come up is when a company lands a few big customers, they see work is piling up, and suddenly they have to hire quickly because they've seen success, they have a lot of work to do, and then all of a sudden they need to throw resources at that. So people are coming in, they have smart and capable individuals that they need to help solve their problems and deliver on their services, but these people are walking into an operation that was never actually documented. So what people are missing is that you can't onboard a new hire into an operation when it hasn't been scoped. So you end up making it up as you go on, and then you have people operating in silos. They're solving their own piece of the problem, and nobody has figured out how all of those pieces work together. So you have an owner that has a vision, and he has to go, or he or she has to go from running it all and doing it all themselves to trusting other people to being those operators. But they don't have all of that knowledge. And so that's where those gaps happen. And that's where the operations break down. And that's where you have the issues with regulatory frameworks and policy and procedure breakdowns. And the fix isn't always more lawyers. It's scoping operations, it's documenting your models, and it's building training and onboarding before you scale the headcount. And the companies that do grow without compounding the risk, the ones that don't pay twice, um, they can do that work and they don't have to redo it again once they've put in those foundations.
Well said. Let's get a lawyer on your side. Erin, thank you so much for sharing your insights today.
Thank you.
Folks, thank you for joining us on Cause for Counsel. If you'd like to learn more about Erin Skinner and Erin Skinner Law, visit erinskinnerlaw.com. Be sure to subscribe, leave a review, and share this episode with business owners and operators looking for practical legal guidance as they grow. And come on back next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.